This is how American Airlines successfully blocked a rule that would have simply required them to tell you the price of checking a bag before you buy a ticket. April 2024 brought the finalization of Department of Transportation regulations requiring airlines to disclose baggage fees, change fees, and cancellation fees up front, right at the moment you first search for a flight. Government estimates put the annual consumer savings at within weeks. 8 major airlines filed a lawsuit to stop it. And their argument went like this: showing you their fees would, quote, greatly confuse consumers. They won. And here's what makes this genuinely absurd. The European Union has required this exact kind of price transparency since 2008, which means American travelers have spent 17 years flying blind on fees, while the rest of the developed world shops with full information. What follows is a breakdown of exactly what these rules would have done, why airlines spent millions fighting them, and what all of it means the next time you book a flight. The Biden administration called it the Enhancing Transparency of Airline Ancillary Service Fees rule, and understanding what it actually required makes the airline's legal arguments land differently. 5 specific fees had to appear on the very first search results page. First check bag, second check bag, carry-on bag, change fees, and cancellation fees. That's the entire list. 5 fees displayed when you first see flight options. Some details mattered quite a bit here. Airlines had to show these fees clearly, conspicuously, and accurately, and they couldn't hide them behind a hyperlink, meaning no tiny link that says "click here for fee information" buried at the bottom of the page. Pop-ups and expandable text got the green light, but the fees themselves had to be visible. Passenger-specific pricing added another layer to the requirements. Frequent flyers who get free checked bags would see that reflected in their display, and the same went for holders of co-branded airline credit cards that waived certain fees. The whole point was showing people their actual costs rather than some generic fee structure that might not apply to them. Airlines also had to include this specific language for consumers. A seat is included in your fare. You are not required to purchase a seat assignment to travel. That sentence targeted the growing trend of airlines charging extra for any seat selection, which left some passengers believing they needed to pay extra just to have a seat at all. But here's the thing about what the rule didn't cover. Wi-Fi fees stayed off the list entirely. Seat selection fees got explicitly removed from the final rule, even though the original proposal included them. Family seating fees were carved out for separate rulemaking down the road. This was a narrow, targeted rule about the most basic fees affecting nearly every traveler. One final piece made comparison shopping actually work. Airlines had to share their fee data with third-party ticket agents like Expedia, Google Flights, and Kayak. 2 flights sitting side by side would finally show you, before clicking anything, that one would cost $60 more in baggage fees than the other. Understanding why airlines fought this hard requires understanding the scale of money at stake. $7.7 billion. That's what U.S. airlines collected in baggage fees alone during 2024, up from $7.7 billion the year before. Just baggage fees, not seat fees, not change fees, not any other add-on revenue. American Airlines led with $1.50 billion in baggage fees, followed by United at $1.34 billion, and Delta at $1.6 billion. And this is where the numbers get interesting. Frontier Airlines, a much smaller carrier, pulled in $61.6 million, while Spirit Airlines collected $7 million. Those last 2 figures matter because of what they represent as a share of total revenue. Ancillary fees, meaning all the extras beyond your base ticket, account for 62% of everything Frontier brings in. Spirit sits at 58.7%, and Allegiant comes in at 50%. These ultra-low-cost carriers aren't really selling flights at all. They're selling a base price that gets you in the door and then making most of their money on everything else. Seat fees tell their own story, and that's where the industry seems headed. The U.S. Senate Permanent Subcommittee on Investigations released a report in December 2024 examining seat fees at the 5 major carriers: American, Delta, United, Frontier, and Spirit. Between 2018 and 2023, those 5 airlines combined collected $12.4 billion in seat fees, and the 2023 number alone exceeded. Something surprised even industry observers in that data. United Airlines collected more from seat fees in 2023, about $1.3 billion, than from checked bag fees at one. Seat selection charges surpassing baggage revenue at a major carrier happened for the first time. which signals exactly where the fee structure keeps evolving. Department of Transportation estimates put annual consumer savings from actually seeing these fees at $43 million. Part of that came from reduced overpayment as people chose cheaper options when they could actually compare. The rest came from time savings, valued somewhere between $365 and $84 million worth of consumer hours not spent hunting through airline websites, trying to figure out actual costs. One more number worth knowing: globally, airline ancillary fees hit $148 billion in 2024, which works out to nearly 15% of all airline revenue worldwide coming from charges beyond the base ticket price. The timeline on this makes the whole situation even more frustrating. May 23, 2014 marks when the Department of Transportation first proposed ancillary fee transparency rules, over a decade ago. The initial proposal went through the standard regulatory process with public comments collected, and by January 2017, the DOT had issued a supplemental notice of proposed rulemaking to refine the approach. Donald Trump took office for the first time, and that changed everything. December 14, 2017 brought the withdrawal of the 2014 proposal, with the stated reason being compliance with Executive Order 13077, one requiring agencies to eliminate regulations. The fee transparency rule died without ever taking effect. 4 years passed before movement started again. July 2021 brought President Biden's signature on Executive Order 14036, titled Promoting Competition in the American Economy, which directed the Department of Transportation to address airline fee transparency. A new notice of proposed rulemaking hit the Federal Register on October 2, 2022, and the public comment period closed on January 23. The DOT held a public hearing on March 30, 2023, and on April 24, 2024, Transportation Secretary Pete Buttigieg announced the final rule. Official publication in the Federal Register came on July 4, 2024 was the scheduled effective date. Airlines didn't wait around. On May 13, 2024, less than 3 weeks after the rule's publication, Airlines for America filed a lawsuit in the Fifth Circuit Court of Appeals. American, Delta, United, JetBlue, Alaska, Hawaiian, Spirit, and Frontier all joined as plaintiffs. Southwest Airlines stayed out of the lawsuit, and that absence mattered. At the time, Southwest remained the only major U.S. carrier still offering free checked bags, which meant they had less to lose from fee transparency since they weren't charging fees that would suddenly become visible. June 17, 2024 brought an amicus brief from the U.S. Chamber of Commerce supporting the airline's position. The rule technically took effect on July 5, 2024, but the Fifth Circuit issued a temporary stay on July 29, blocking implementation while the case proceeded. Secretary Buttigieg responded on social media with this: "The airline industry lobby is trying to tie this up with lawsuits, but we will not back down from protecting passengers. Airlines are simply wrong to argue that merely having to disclose their fees would irreparably harm them. It's common sense." The arguments airlines made in court deserve examination because they reveal exactly how the industry frames this issue. Statutory authority formed the primary argument, with airlines claiming the DOT never received permission from Congress to mandate this kind of disclosure. They also called the rule arbitrary, capricious, and an abuse of discretion, while arguing it violated the Administrative Procedure Act, the law governing how federal agencies create regulations. Practical concerns came next. Airlines claimed the rule would force them to spend millions re-engineering their websites. Frontier and Spirit pushed even further by arguing the disclosure requirements violated their First Amendment rights, that the government was compelling them to speak in ways they hadn't chosen. But here's the argument that got the most public attention. Airlines for America claimed the rule would mandate clutter and clunky search protocols, causing delayed and unclear search results, neither of which consumers want or need. Translated plainly, showing you the fees would confuse you. Secretary Buttigieg's response to that argument went viral. "We just issued a rule requiring airlines to inform you, before you buy a ticket, of fees they will charge you. Now the airline lobby is suing us, saying that if you have the right to that information, it will confuse you. For once, I am speechless." January 28, 2025, brought the Fifth Circuit ruling, now under the Trump administration. The court found that the DOT violated the Administrative Procedure Act by relying on a cost-benefit study that airlines never got an opportunity to comment on. This was a procedural failure rather than a ruling on whether transparency itself made sense. The court didn't permanently strike down the rule, which matters quite a bit. It remanded the case back to the DOT for additional public comment on the cost-benefit methodology, and the court explicitly upheld the DOT's general authority to issue fee disclosure rules. October 2025 brought another development when the full Fifth Circuit agreed to reconsider the case en banc, meaning all the judges on the court would review it together instead of just a 3-judge panel. That review vacated the January ruling, and the case remains ongoing. American exceptionalism takes on a less flattering meaning here. EU Regulation EC 108/2008 took effect on November 1, 2008, and under that law, airlines must display the final all-inclusive price, including all taxes, airport charges, surcharges, and fees, from the very first time a price appears before a consumer. Not later in the booking process, not on some subsequent page, but the first time you see a price. EU law requires base fares, taxes, and charges to be itemized separately so consumers can see exactly what they're paying for. Optional extras like baggage, seat selection, and travel insurance can't be pre-selected, meaning they must be opt-in only. Hidden fees and pre-tick boxes that add charges you didn't ask for are both prohibited. The difference between Europe's approach and the now blocked US rule comes down to this. Europe requires all-inclusive pricing from the start, while the US rule only required disclosure, meaning airlines could still show a base fare first as long as the fees were also visible. Post-Brexit Britain retained EU Regulation 108/2008 as domestic law, with the UK's Civil Aviation Authority enforcing these rules. The Digital Markets, Competition and Consumers Act of 2024 enhanced their enforcement powers starting in April. Canada enacted air passenger protection regulations in July 2019, requiring total price advertising that shows all taxes, fees, and charges. Their 2024 federal budget announced plans to strengthen fee transparency further. Australia stands out as the outlier among developed nations with no aviation-specific fee transparency rules, relying instead on general consumer protection law. Australian authorities take enforcement seriously when airlines cross the line, though. The Australian Federal Court ordered Qantas to pay $100 million in penalties during 2024 for selling tickets on flights that had already been cancelled. Core principles on consumer protection adopted by the International Civil Aviation Organization in July 2015 recommend price transparency as a basic consumer right. These recommendations don't carry binding force, but over 60 countries have now implemented some form of consumer protection regulations for air travel. The bottom line on all of this: the United States sits 17 years behind Europe on basic fee transparency, and the rule that airlines successfully blocked would have been standard practice in most developed economies. January 20, 2025 brought President Trump's regulatory freeze across all federal agencies. 8 days later, Sean Duffy won confirmation as the new Secretary of Transportation. Duffy's appointment drew scrutiny for a specific reason. Between 2019 and 2020, he lobbied for domestic airlines through BGR Government Affairs for the Partnership for Open Skies, a coalition including American, Delta, and United. Policy decisions affecting the same airlines he recently represented now fall under his authority. Senator Elizabeth Warren formally requested the Office of Inspector General investigate his policy decisions for potential conflicts of interest. January 31, 2025, brought Executive Order 131/19-2, titled Unleashing Prosperity Through Deregulation, which established a new standard requiring agencies to repeal 10 regulations for every one new regulation they issue. Executive Order 142/19 followed on February 19, directing agencies to identify and repeal unlawful regulations. The DOT issued a request for information on April 3, 2025, seeking public input on which regulations should be repealed. Airlines for America submitted a 93-page response. September 2025 brought the DOT's announcement that it was considering rescinding the Biden-era fee transparency rules entirely, a separate rule that would have required airlines to pay $200 to $75 in compensation for airline-caused delays and cancellations. Got formally withdrawn on November 17, 2025. The stated rationale was that it would create unnecessary regulatory burdens. December 5, 2025 saw the DOT pause enforcement of some airline refund requirements until June. Official communications from the administration hold that these rules went beyond what Congress has required by statute. and that airlines have strong incentives to take care of passengers and already do so voluntarily. A few details from this story deserve highlighting because they reveal something about how this industry actually operates. $26 million in bonuses. That's what Frontier and Spirit Airlines paid gate agents between 2022 and 2023 specifically for catching passengers whose carry-on bags exceeded size limits, forcing them to pay checked bag fees at the gate. $26 million in bonuses for catching bags. Senator Maggie Hassan of New Hampshire captured the dynamic at the December 2024 hearing with this: "We're all captives on your airplanes at a certain point. You just say, you want to pick a seat? We're just going to charge you some random amount more." Airlines for America dismissed the Senate's junk fees report as just another holiday travel talking point. United Airlines CEO Scott Kirby defended the fee structure by putting it this way: "If you don't want to check a bag, you shouldn't have to pay the implied cost of checking a bag. We're creating options for customers." John Brayult of the National Consumers League summed up the consumer experience: "We don't want to have to do algebra and advanced trigonometry to figure out what it costs." American Airlines collected $7.207 billion in baggage fees during 2020. Seat fees added another $3 billion on top of that. They fought for a decade to avoid telling you these fees up front, and they won. The rule requiring basic transparency, showing the bag fee when someone searches for a flight, was first proposed in 2014, withdrawn in 2017, revived in 2021, finalized in 2024, blocked by the courts, and now faces rescission by the current administration. European travelers have been shopping with full-price transparency since airlines argued that showing you their fees would confuse you. They argued that disclosure would cause them irreparable harm. A federal court found that the government didn't follow proper procedure in calculating whether transparency was worth it. The next time you book a flight and find yourself clicking through multiple pages trying to figure out what your bag will actually cost, remember that someone fought very hard to make sure you have to do exactly that. That's the story of airline fee transparency in America. Thanks for watching.